Good morning. My name is Nate Bernstein. I'm an attorney in Los Angeles, California. Thank you for joining me this morning for part 2 of a 2-part webinar, especially for YouTube and my friends, colleagues, clients, and associates out there on the subject of effective negotiation strategies and tips for resolving and settling real estate and legal disputes. Thank you for joining me. Again, my name is Nate Bernstein. I'm the managing counsel of the LA Real Estate Law Group. We are a premier real estate transactional and litigation law firm located in Encino, California. We also handle business law and business litigation matters, and we represent creditors in bankruptcy matters, and we focus on creditors' rights. Thank you for joining me this morning. This is part 2. Regarding negotiation skills and strategies, I went through 10 in part 1, 10 points of light regarding effective negotiation strategies. Point number 11 is that money does talk. When you go into a negotiation or mediation session, arm yourself with sources of funding to fund a resolution. Very important. Having insurance in place or a source of capital or loan funding or a quote-unquote sugar daddy is a great asset to help you resolve any kind of legal or real estate problem. Insurance policies are an important asset protection tool and can be a shield to protect your interests in any settlement negotiation and can fund a resolution. So, money does talk. Have a source of funding when you go into a negotiation session. Number 12, silence can be a very powerful tool to use in negotiation. Being silent at the right time has the implied message of no way. I don't agree with my opponent's position or my adversary's position. And it can also mean you have to wait, or your position on the other side is simply untenable and ridiculous. And the use of silence at the right time in a negotiation session may force the other side to change its course or grant some major or meaningful concession in the negotiation session. So number 12, silence can be a very powerful tool to use in negotiation. Number 13, before you negotiate a major issue, seek feedback and ideas from experienced and knowledgeable third parties about your problem. The managing real estate broker, experienced real estate agents, experienced asset managers, attorneys, mediators, retired judges, colleagues, and roundtable with colleagues on the situation. Roundtable, sit around, try to figure out what are my settlement and resolution options and scenarios. Given the risk of ending up in a worst case scenario, is my position valid and credible? Can I resolve it after consulting with my colleagues and other experts? Speaking to third parties will definitely help you going into any negotiation or mediation session. Number 14, if you use a mediator in negotiation, please learn everything you can about the mediator's professional and personal background that you can. Does the mediator have a bias because he or she is hired by the same opponent party over and over again? If a mediator is getting paid by an opponent on multiple cases, a bias can definitely develop in favor of that party. That's not the kind of mediator you want in your situation. This type of mediator may be so biased that he or she will not be fair to your side in the negotiation. Does the mediator understand the subject matter? Is the mediator considered somewhat of a quasi-expert or an expert in the field? If you're dealing with an issue regarding, let's say, title insurance, has the mediator litigated or been experienced in any way regarding title insurance issues or title insurance companies and practices? Does the mediator understand the terms and conditions of the different types of title insurance policies? And also, does the mediator explain why each side's position is valid or invalid? So please do your due diligence as to who your mediator is. Number 13, I have developed a financial bracket analysis to achieve a workable range of settlement for monetary settlement cases. If you contact me at my office, I will give you an overview for no charge about how my financial bracket analysis works. I've used this in actual legal cases and real estate matters to settle money disputes and property damage cases. I call it the Nate Bernstein financial bracket analysis. So give us a call at LA Real Estate Law Group, and I'll give you an overview of how my financial bracket analysis works. Number 16, if you have to pay money to settle a dispute, don't offer all that you have on the table on the front end. Make your opponent wait for it a little bit and make incremental offers over time to get into the desirable settlement bracket. This time factor in this incremental offer strategy really helps to get both sides into a bracket when parties are negotiating a money settlement. Number 17, don't be afraid to call out an opponent or an adversary's position as being unfair, unreasonable, not realistic, or even unlawful, if you can back up your point and proposition with concrete reasons. Don't make it a personal attack. Attack and chip away at the position, not the person. If you can constructively and effectively and tactfully attack your opponent's position in a mediation or negotiation session, you can really achieve a lot on your side of the coin. If their position is unlawful or not reasonable or not realistic, you can try to obtain concessions for your benefit and your side's benefit. Number 18, take a calculated risk and ask for all and more than you want in a negotiation session. Stretch the rubber band to its breaking point and see how the opponent reacts. What do you have to lose? Nothing. You might get more benefits and concessions than you anticipated. For example, if you're negotiating a lease, you might want to sort of lowball the offer at first and see where they go with it. If they're going to come down, well, then you've achieved something right away. If you're trying to get them to come down in price per square foot, for example, in a lease negotiation. Number 19, if you are a fiduciary in a fiduciary capacity and you represent a principal, for example, you are an attorney or you are a real estate agent or real estate broker, or you have a power of attorney. If a client or principal wants you to keep some information confidential in a negotiation session, then please keep it confidential. Respect the privacy of the principal if you are a fiduciary, unless the law mandates disclosure. If the law mandates disclosure, then you are privileged to disclose it. But usually, if you are a fiduciary, you keep the information confidential so that you keep and maintain the trust of your client or principal in the situation. Number 20, please obtain all terms of a transaction, offer, acceptance, counteroffer, and specific settlement terms or negotiation terms in writing. In writing, very important. Personally signed and dated by the party. That is very, very important to get a wet ink signature to bind a party to a particular settlement, to a particular contract, to a particular counteroffer. And it is very good to have a party agree by email, through an email signature, to the terms and conditions, and also to follow that up with a written wet signature in blue ink, such that the party has agreed to and understands all of the terms of a particular transaction, settlement, deal, contract, whatever it is. Lay out all the details, put it in writing, have the party sign it. Otherwise, you're heading for trouble. The agreement terms may be unclear, and the agreement may not be enforceable if it's required to be in writing. You always want to have things in detail and set forth in writing, signed by both parties, and give the other side an opportunity to consult counsel regarding the particular transaction. So that is 10 additional points of light to help you in your negotiation session, whether it is a real estate transaction or a lease or a purchase and sale transaction or a settlement of a complex multi-party legal dispute. These are all very important points of light that I have gained insight on after 23 years in legal practice in Los Angeles. So I thank you so much for watching this webinar. My name is Nate Bernstein. I'm the managing counsel of LA Real Estate Law Group. If you need to consult with us on any particular legal issue, we do offer a free telephonic phone consultation, which I guarantee you will be beneficial to you. My number is 818-383-5759. That's 818-383-5759. Please give us a call if you have a real estate, business law, or bankruptcy creditors' rights matter that you need assistance with. So I thank you so much for your time, and I wish you all of the best in your negotiation session.